Legal wrongs and forgotten rulings, why the Allahabad High Court rebuked UP Shia Waqf Board over 1934 deed. In a striking judicial rebuke rooted in decades-old legal history, the Allahabad High Court on May 30 imposed a penalty of 15,000 on the Uttar Pradesh Shia Central Waqf Board, holding it culpable for suppression and concealment of material facts. In a case that has its origins in a 1934 Waqf deed by a nobleman of colonial-era India. The court's order marks a significant moment in the evolving discourse on religious trusts, historical property disputes, and the limits of institutional authority. The controversy, spanning over 9 decades, traces back to Bareilly, where Nawab Mohammad Hussain Khan, a Shia aristocrat, executed a Waqf deed on 27 March 1934. The deed covered 17 commercial shops adjacent to his residential mansion or kothi and a private Imambara or ceremonial hall of religious significance for the Shia Muslim community. After his death, the Nawab's only heir, Nawab Anwar Jahan Begum, approached the civil courts in 1952, contesting the religious legitimacy of the Waqf deed. The Bareilly court at the time unequivocally held the Waqf invalid, stating its objective were neither charitable nor religious in nature, thereby striking down the claim. The heart of the case lies in the interpretation and legitimacy of the 1934 Waqf deed. While the Shia Waqf Board maintained that the earlier ruling only nullified the deed in relation to the 17 shops and not the Imambara, the High Court decisively rejected these lines of reasoning. The court observed that the 1952 judgment had effectively declared the entire Waqf invalid due to its failure to satisfy foundational requirement of being pious, religious, or charitable under Islamic or Indian trust law. Moreover, the board's failure to discourse the full procedural history, especially the existence of parallel petitions on the same issue, was seen as a deliberate act of presided over Justice Jaspreet Singh. The Allahabad court meticulously dissected the board's argument and legal trajectory. When pressed about the omission of the key facts from their filing, the board's counsel reportedly fined ignorance, a reaction the court deemed unacceptable. Citing Supreme Court precedents such as A.V. Papaya Sastry versus Government of Andhra Pradesh, the judge reiterated that concealment of material facts is sufficient ground to dismiss a case at any stage. This saga underscores the enduring complexity of religious endowments in India's legal system. It is a reminder that historical wrongs, once adjudicated, must not be reopened without compelling cause, and certainly not through concealment.
Thank you so much for watching this video. Don't forget to like, comment, share, and subscribe.